intellectual property rights. I am Dr. Amirdha Gill, working as professor in the Department of Physics, School of Basic Engineering and Sciences, PSN College of Engineering and Technology. In this class, we will see about intellectual property rights. IPR, intellectual property rights. So, first Indian patent was very old enough and it has been given in the year 1856. A civil engineer, George Alfred D. Penning, got it and he petitioned the government of India for grant of exclusive privileges for his invention and efficient panka pulling machine. Okay. So, before we go into the subject what is meant by intellectual property rights or intellectual property, we will see some of the examples to get to know about in a few easily. Okay. So, first is Coca-Cola. So, if you see the Coca-Cola tins, you might have seen the Coca-Cola above that a R symbol, that is registered. Okay. Then an Apple iPhone is one of the example where we have various forms of IP in it. Then Harry Potter, Polaroid instant camera, then DNA copying processor. These are some of the examples. And being a physicist, I would like to give an example from magnetic levitation. So, where the electric train or the magnetic levitated train does not run over the rails, instead it is moving with a air cushion without any friction at a height of 5 cm to 10 cm. Okay. So, this has been a patented one with the name electromagnetic inductive suspension and stabilization system for a ground vehicle. Now, we will see what is IP or what is intellectual property. So, shortly it is called as IP, which is something produced using human intellect which has commercial value. I repeat, it is a property started from the human intellect or used from the originated by human intellect and it has a commercial value. So, it is a term referring to a brand or it may be an invention or a design or other kind of creation which a person or business has legal rights over it. Almost all businesses own some form of IP which could be an asset to the business. What we have seen is intellectual property. Then what is intellectual property right? So, if you have an asset, then you have the right over it. Okay. So, not to be confused with IP, it's a right vested in the asset, not the asset itself. So, it's a right vested in the asset, not the asset itself. So, it may be an idea or it may be an invention. So, it may be a patent registration or a customer even a price list, a right of confidentiality like a KFC secret, a secret production method, a right to a trade secret, a particular way of representation of IP, copyright or a design registration is an IPR, a brand or trade name is IP, a trademark registration is an IPR. Okay. So, this is to differentiate IP and IPR. Okay. So, IP is intellectual property. When we register it, it will become a intellectual property right. So, there are several forms of IPR. So, copyrights, patents, industrial design, trademarks, trade secrets, plant varieties, integrated circuits, geographical indicators, GI. So, what is copyright? It protects written or published work. Whatever has been written, the textbook or any reference book, whatever we are reading, any journal, they are all copyrighted. So, such as books, songs, films, web content and artistic work. Patent. It protects the commercial inventions, a new business, product or process or growth. Design. So, it protects designs such as drawings or computer models. Trademarks. So, protects signs, symbols, logos, words, sounds. I will give you example that distinguish your products and services from those of your competitors. geographical GI indications to identify agricultural, natural or manufactured goods originating from a definite territory in India. Example, Kanjipuram silk saree, Alfonso mango, Nagpur orange, then Kadala Muttai, Kovilpatti Kadala Muttai, Chikkis, then Tirunelveli Alva, all these things are regional. Plant varieties. So for the establishment of an effective system for protection of plant varieties and rights of farmers and plant breeds, they are formed. Then integrated circuits. So to protect layout design of a semiconductor IC. Trade secret. To protect information relating to trade which the owner of the information wants to keep as a secret. Example, Coca-Cola, KFC chicken. Now there are two things. One is IP, another one is IPR. So if you have a new invention or a new copyrighted one or new design or new trademark, if it is unregistered, it comes under IP, unregistered. Or if you patent it, if you registered it, if you make it as a right, then it is called as registered IP. Okay, so what is the exact fine line difference between registered IP and unregistered IP is, if you do not register, others are free to exploit your creation. Okay, so if unregistered IP, you have legal rights over your creation, but still if someone claims, you don't have a registration. Okay, so unregistered forms of IP can be copyright, unregistered design right, common law trademarks and database rights. Okay, but registered IP you will have to apply to an authority. In our government, in Indian government, we have IPO, Indian Patent Office, such as the Intellectual Property Office in the UK, to have your rights recognized. Registered forms of IP include patents, registered trademarks and registered design rights. Copyright is also registerable. So, if it is registered, patents, utility models, registration, trademarks, registered designs. Okay, so the inventor, creator or designer has no rights until they make a registration. So ownership can be checked by looking at the register. Next is copyright with C symbol. Then database rights unregistered, trademarks, TM. If it is going for a trademark registration, they'll give the symbol TM. These rights are unregistered, they exist from the moment the works are created. Ownership is harder to clarify without a register. Both unregistered and registered rights together are called intellectual property. One product can be with many intellectual property rights, IPR. For example, Apple iPhone. Okay, so in Apple iPhone, the shape of the phone has been registered for design. And iPhone, Apple, iCloud, Lightning, some app icons such as passbook, all these things are registered trademarks. Then copyright, the software, ringtones and images has been copyright. Then patent, for technology or product and operate the phone, wireless technology, software on game processing, networking, data transfer, all these things are patented. Then trade secrets, kept in-house, never published. Criteria for patents, Patent Act 1970 we are following. So a new product or process involving an inventive step and capable of industrial application comes under invention or can be patented. 3 steps. One is novelty, non-obviousness, useful. Useful is utility. Okay. So what is novelty? New. What is non-obviousness? New inventive step. So publish or patent. So if we publish before we register the patent, before we file the patent, then it is published already. Then it cannot be stand for novelty. If it is there already in the public domain. So So patenting and commercialization by others cannot be done. Grace period is 12 months, meaning if you have your own paper published out of that particular invention or published out of that particular research, then a minimum of 12 months grace period is given. Okay, within that you are supposed to file a patent. Before we go for patenting, to reduce the cost of patenting and related things, we have to do for patent search. Okay, so first we will do research, then we will do the invention, then we have to go for commercialization. So there are two kinds of search. One is prior art search, another one is patentability search. Prior art search means whether this particular knowledge or particular invention or particular research or particular product or particular process is already in the public domain. Either patentable document, patented document, or any journal or any research magazine or any papers or any public domain. If it is available, then that is called as prior art. Okay, then patentability search. So according to that Patents Act 1970, we have some of the list of things which can be patentable, which cannot be patentable. So that patentability search also we are supposed to take before we go for patenting. Then commercialization. So that we have two things. One is freedom to operate search. Second one is validity search. Significance of patent search. So avoid duplicating R&D effort. Determine the patentability of inventions as we saw. Avoid infringing other inventors' patents. Then time and cost saving, definitely. Exploit technology from non-granted invalid patents. Exploit. Then planning for business decisions. So there are few free databases available for patent search. Okay, so all IP offices we can search. So USPTO, Indian Patent Advanced System Search, and eSpaceNet, Patent Scope, Japan Platform for Patent Information. All these things are government IP offices where we can do patent searching at free of cost. Inventive step. So there are three steps I said: inventive, novelty in inventive, then non-obviousness, utility. So a feature of an invention that involves technical advancement as compared to the existing knowledge, or have economic significance, or both, and make the invention not obvious to a person skilled in that. Industrial application. So invention is capable of being made or used in any kind of industry. Who can apply? True and first inventor, assignee of true and first inventor, legal representative of a deceased person, then patent agent. But authorization is required, non-mandatory to apply through agent. Types of patent applications. So there may be 5 different types. One is ordinary application, then convention application, patent cooperation treaty PCT application, patent of addition sometimes, then divisional application. These two, patent of addition, I have applied for some patent. After some months back, after an year, I feel that this also has to be added to that patent, then it is called as patent of addition, can be done. Divisional application is after we apply, either the examiner or the patent office may ask me to divide the application into more than one application. Okay, because they can stand on their own. So in such cases, we will go for divisional application. So basic conditions: novelty, that is new. Inventive step or non-obviousness, it could not be obviously deduced by a person having ordinary skill in the relevant technical field. Okay, an industrial application, it must be capable of being used for an industrial or business purpose beyond a mere theoretical phenomenon or be useful. Subject matter must be accepted as patentable under law, because there are some non-patentable list available with the section 3. Okay, so the invention must be disclosed in application in a manner sufficiently clear and complete to enable it to be replicated by a person with an ordinary level of skill in the relevant technical field. Repeatability. What exactly can be patented? Okay, so innovations with a technical character may be a product, process, method, apparatus, or its use, or a combination of this also. It can be a product along with process, or process along with the product, or anything. Products protect, patents protect inventions which solve technical problems. So chemical substances, pharmaceuticals, processes, methods, use, products, devices and systems like armed chair. How patents are used? So protecting products and processes, increasing turnover and profit, attracting investors, licensing, cross-licensing, blocking competitors, building reputation, trolling not used. So as I mentioned, there are non-patentable invention or few inventions or some sort of inventions which cannot be patented according to the Patent Act. Okay, so a discovery or a scientific theory or a mathematical method which cannot be patented. Aesthetic creation cannot be patented. Scheme or rule or method for performing, playing game, doing business, computer program cannot be patented. A presentation of information cannot be patented. It can be copyrighted. So contrary to public order or morality, I am finding a machine to shoot the people cannot be patented. A procedure for surgical treatment, treating either animal or human cannot be patented. The method of treatment. Who can file what? So a trademark can be filed by a lawyer or a litigator. Patent can be filed by a patent attorney or patent agent, and copyright can be done by patent attorney or patent agent, and once again design can also be done by patent attorney and patent agent. Only the trademark cannot be filed by a patent agent. Okay. Eligibility criteria. He should be a citizen of India, completed 21 years of age, should have completed a degree in either science, engineering or technology. Final year students can also apply, should appear and clear the patent exam, should have paid the prescribed fees. Every year or every alternate year, patent agent exam will be announced for. Encourages innovation. The legal protection of new creations encourages the commitment of additional resources for further innovation, economic growth, and safeguards the rights of creators by then other person, third party may not use it. It facilitates the transfer of technology in the form of foreign direct investment, joint ventures and licensing. Next, IPR policy and outcome. IPR policy adopted in May 2016 to guide future development of IPRs in the country. Its clarion call is Creative India, Innovative India. India has made a number of changes in its IPR regime to increase efficiency and has cut down the time required to issue patents. India is very poised to focus on R&D. This has been reflected in its improved ranking in Global Innovation Index over the years. Government's efforts to strengthen national IPR policy, IP appellate tribunal, e-governance, and commitment to abide by the TRIPS agreement of WTO in letter and spirit helps in improving perception of India globally.